the defendants owed him a duty, but it was not the duty of an insurer. Unless you find that the accident was caused by the negligence of the railway company, you cannot hold that defendant liable. You cannot hold the other defendant liable unless you find that the negligence of the driver of the truck contributed to cause the accident. You may find neither liable. You may find both liable, or you may find one liable. Your verdict, if you find for the plaintiff, must carefully show against which you intend your verdict to be, remembering that the burden is on the plaintiff to show you by a fairly greater weight of the evidence you believe every fact upon which he relies, including the cardinal fact of the negligence of either defendant and each of the defendants in this case. He cannot recover against any defendant that he has not shown to be negligent by that burden of proof by a fairly greater weight of the evidence you believe. Now, assuming, and only assuming, that you have passed by that point of liability, you come to the nature of the injuries. There is no evidence that the plaintiff was negligent and contributed to the accident so far as the cutting by the glass on his hand is concerned. I believe one of the defendants contends that he must have been negligent to have fallen when nobody else fell on the car. Of course, if you find he was negligent in any further action or failure to act which might have been responsible for a more serious injury, why then you must take that into consideration, because he cannot recover if his own negligence contributed to any extent to his damage, or for any damage to which his own negligence contributed in the slightest degree. With that exception, my charge as made stands on the liability. Now to come to the nature of the injury, here is the big controversy in the case that has taken so much time and attention by you and by counsel and by myself. The plaintiff contends that he had not merely these superficial bruises and contusions on his hand, and I believe his face, but also that he had a very serious injury to his head. There is where the fight centers. The plaintiff has some testimony to the effect that he had lumps on his head appearing after the injury, and which the doctors connect with the injury. The defendant offered evidence to the effect that he had no marks on his head after the injury, and moreover, the defendant gives evidence to the effect that anything that he had the matter with his head was not due to the accident, but to something else. That is, by expert testimony, a matter of opinion on both sides where offered. The direct medical testimony is to be considered only as to the facts. Of course, the other is a matter of opinion, which you may take or from the doctors as you like. That is merely advisory to you. As I say, there are two claims. The plaintiff claiming an injury which the defendant says never existed. The plaintiff claiming that this injury is due to the accident, and therefore that the operation for it was due to the accident. With the pain and suffering and disability that accompanies it, the defendant saying no, that whatever developed after was due to, in some cause, either some illness of his or an accident happening long before, for which another defendant, of course, is responsible. A serious aspect of this verdict is to be found here. That plaintiff made a claim against an accident insurance company with which he had a policy, and against a health insurance company with which he had a policy. Ladies and gentlemen of the jury, the protocol in the trial of civil actions is to sever the question that arises in a litigation into two classes. One class of questions we call the questions of law, and the other class of questions we call questions of fact. The questions of law comprise rulings upon objections concerning the admissibility of evidence, the conduct of the trial in general, and the determination of motions made during and at the close of the case. These questions of law, which include advice to the jury as to the law of the case, are all for the judge to pass upon, and the jury is bound to take the court's rulings on such questions. On the other questions, which we call the questions of fact, the law says a jury of 12 people must pass, and they are paramount in determining such questions of fact. This system of conducting trials does not ask for a judge's idea as to who is telling the truth, but asks for the jury's finding. Therefore, you are required under the law to decide this case upon your conscientious conclusions as to what the proof requires you to find in respect to the questions involved. Questions of fact concern the disputes between the parties as to who is telling the truth, Issues of fact, they are sometimes called. One side avers that a certain thing happened on a certain occasion. The other side contends that another thing happened. The difference between them is an issue or a question of fact, and it is the jury's function to decide those questions. You remember that when you were sworn as jurors, you swore you would decide this case according to the evidence, and that expression in your oath tells what your duty is here, which is to decide it as the evidence requires you to decide it, and not as you might choose to decide it as a matter of sympathy, or as you might decide it if prejudice and determination of what the facts are and the evidence in this case require you to say is the truth. The most important thing in the conduct of litigation is that the truth should prevail, not that one person should keep his or her money. Those things are not nearly so important as is the proposition that the truth should prevail in a court of justice. With that admonition as to your duties, let us see what the questions of fact are which you decide upon the evidence. In this case, the plaintiff claims the justiciable right to recover from the defendant a certain sum for brokerage commissions. It was 175. Did you get it?
Pretty good.